Hello, hello. Thank you all for joining us today. This is another rendition of Holmquist and Gardner webinars. And so I'm here today, Robert Maxwell, one of the partners at Holmquist and Gardner. I'm here with one of our associates, Phil Neale. He actually put on his glasses for this one, so it's it's going to be a good time. But we want to run through some stuff here. There's been a lot of changes recently within Washington regarding landlord tenant rights, different laws that are coming into place, different House bills that have been passed. And so we just felt that this was a great opportunity to get everybody together, talk through some of these issues on a high level of where they're going, what we're seeing, and look at the reality of where the law is right now. This is a hyper technical field, and it's as anybody that's been in this area or this arena for a while knows, there's been a ton of changes since COVID, and it's consistently evolving. And it's happening very fast. So it's a good time to sit back, learn about some of these updates as they're coming through. We'll talk through some best practice points, as well as just some value of where things are going and what we see in the future. Phil, if you want to go ahead and introduce yourself here.
Thank you, Rob. So for all our returning viewers today, it's great to have you back. For anyone new, my name is Phil Neale. I've been working with Holmquist and Gardner for about 3.5 years now. Prior to joining Holmquist and Gardner, I did work primarily in high-volume eviction work. I've since expanded my practice a little bit to include other areas, but I still landlord-tenant law still remains a large part of my practice. Rob is correct that it's a very quickly developing area of the law. There have been many changes in the last few years. I'd like to think that's been pretty good for my development as an attorney, and we look forward to updating you on some of the most recent changes taking effect.
All right, and then for those that don't know me, I'm Robert Maxwell. I'm one of the partners here, and just a brief overview of Holmquist and Gardner, but we are a business and real estate focused firm here in Seattle, Washington. In my practice, I'm primarily on the litigation side. Our firm does have a litigation team and a transaction team, so we deal with the full gambit of client needs, whether it's transactional or if it has to go down the route of litigation. For those of you that are returning clients, have been to one of these webinars before, we too like to have this as an open session. So if there are questions, if there are things that come up, go ahead and pop it into the chat, and we'll try to get them as they go. We will have the chat afterwards as well. And so a big part of that is we can look at that. If you send us an email, if you send us some contact information, you had a specific question or something that came up that you wanted some clarification on, happy to run through that, happy to talk. But really we want to give a more focused view on this ever-evolving area of the law and jumping into things today. So today, the big thing here is the updates on the current timelines that we're seeing within the court system for unlawful detainers. We want to go through some high-level issues that we're seeing on what we call non-monetary defaults, issues that can happen and do tend to come up, and how best to deal with those. We want to run through some best practice situations with regards to notices. As we talked about, this is a highly technical area of the law, and a lot of these cases you'll see coming through will hinge on whether the initial notice was correct or defective. I want to run through a little bit on settlement agreements with tenants and some nuances that have come with regards to the courts and how they view settlements agreements and how those go through. And really, this is a big change that we've seen within the dynamics of the landlord-tenant situations, where settlements agreements that we were able to go through and work with tenants and work with the landlords to come to an amicable resolution, that's really shifted a lot in the last couple of years. And so we're going to talk about the dynamics of that, what comes up, and how best to practice that point. And we're going to look at some alternatives to unlawful detainers. We're going to look at some of the specifics around lease renewals and how those play out. And then we really want to jump into what I'm sure a lot of people are curious about is these House bills that have come through recently within Washington State, specifically House Bill 1003 and House Bill 1217. So that's kind of the agenda for today. And again, if you have any questions or anything of that nature coming through it, let us know and we'll try to get to those as we go. Now, the first thing we want to look at and just give a very almost 10,000 foot view on what's going on, what's the current dynamics with the court systems. Everybody saw with COVID, with how the courts were functioning, that there was a big stop on everything. There was almost, in early 2020, the courts came to a screeching halt. And coming out of that, they put forth a couple different systems to alleviate some of the housing issues and also create some nuances that were different than the previous sides of how the unlawful detainer process works. But I think a great starting place on where that is just the background on unlawful detainers and where this comes from. And this is statutorily created. So the Landlord Tenant Act under 5918 in Washington was created primarily as a means to ensure that possession of a property was a quick and efficient process when there was a dispute. Most of the time those come from a monetary dispute going into a system, and the courts actually developed this alternative to a traditional trial route to expedite the process of alleviating possession issues. Whether the tenant could still stay in possession or whether the landlord had a right to repossess the premises. And so what we're seeing right now is there was a expedited process, and it's still there. It's still a process that's been created. It's been turned a little bit on its head. I think anybody that's gone through the process recently, and I'm going to let Phil speak on some specifics here, but anybody that's gone through this process specifically, what used to be a fairly quick in the world of law, 3 weeks to a month process, we're now seeing generally, we're seeing a 5 to 6.5 month process on an unlawful detainer. And so if you've read any of the current news articles coming out, there's been a lot of talk about the frequency and seeming uptick of unlawful detainers being filed within King County. And while that statistic, and there is an increase on that, there's a lot of nuances to where that is and how that's played out. And one of the reasons that we're seeing this is because the process for these is so hyper technical that we're seeing a lot of refilings of the same parties, same tenants. Maybe there's a technical issue wrong with the notice, so a lot of cases are being restarted, refiled. There's a lot of other things that come into play where prior to, and we'll get into this a little more, prior to some rule changes on settlements, we're seeing a lot more outside of the court ability to resolve things, which is benefiting, in my opinion, benefiting tenants and landlords and preventing that really, almost head-to-head kind of frustration match that we're seeing in the current court system. Unfortunately, that's changed a bit, and we're not there anymore. And with those settlement agreements and the inability to really use that as an avenue to resolve the issue, we are seeing an increase in cases filed just because the settlement agreement isn't a realistic opportunity in a lot of the situations. So, Phil, I just want to, boots on the ground and what you're seeing as well in the court system. What are kind of you seeing on timeframes, on the expectations of what we can look for there?
Yeah, so let's start with the time frames, because that's one of the most common questions we get as landlord attorneys. How long is this going to take? When will my problematic tenant finally be out? And the answer to that question is it does vary, and it does depend on the merits of the facts and other circumstances involved. In King County, it's not uncommon for us to be seeing unlawful detainer actions that take over 6 months, with assuming that you are ultimately successful in the end. Robert also touches on a very good point that with a recent case of Princeton, we're seeing a lot of landlords being more wary about entering into settlement agreements, and for good reason. In that case, a settlement agreement was deemed unenforceable with respect to a writ provision because the court held that it violated the tenant's rights under the Landlord Tenant Act. For that reason, landlords are concerned about the fact that their settlement agreements may not be enforced by the court, and thus are opting for the litigation route more often than they otherwise would. Now, can settlement agreements still be reached? The answer is yes, but the agreements must be drafted a lot differently than they used to be, where we tend to see a lot of agreed findings of fact in the judgment. In that effect, they almost act as a confession of judgment, whereby the tenant agrees to move out. Sometimes there's compensation through rental assistance or otherwise. So we've had to get a little bit more creative with how to resolve these issues.
And to that point too, a lot of that is it's shifted the way these settlement agreements work, because a lot of the times we'll have the same thoughts and ideas, and actually tenant and landlord are on the same page with how to resolve it. But now it's being forced through the court. So a lot of the times you will see these resolutions, these amicable resolutions, still going before a court in a filed matter, just to have it signed off by the judge as well, and so that everybody's on the same page, and that it's one avenue towards resolving this issue that otherwise we would have been done out of the court. So in getting back to the news articles that we're seeing, there's this massive uptick on eviction filings, and that statistically may be true, but there's a lot of reasons why we're seeing that uptick. And one of those is the less inclination to enter into an out-of-court settlement with that Princeton case in the mix. And so the other thing that is coming up on kind of these time frames and to note when going through the process of these hearings is the first initial hearing. And Phil, if you want to run through kind of the specifics on the hearing side of things and what you're seeing.
Yeah, so what we're seeing often these days, I'm going to be focusing mostly on King County since that's where we do most of our work. What will happen is first you have to, as a landlord, before you evict a tenant, you have to serve them with a pre-eviction notice, such as a notice to pay or vacate, notice to comply or vacate. There are many different types of notices out there that might apply. After that expires, assuming the tenant has not cured the notice, you would then have to proceed with serving and filing a summons and complaint. Tenant would have a certain period of time to respond to that, and if they do, next step is to set a hearing. Now, this is where things can get a little bit county specific. Here in King County, we're seeing a lot of continuances, especially at the first 2 or 3 hearings. So you can expect as a landlord that the first set show cause hearing is not going to be the one where the judge enters an order unless the tenant simply doesn't show up. So when you factor in all these continuances, that lengthens the process, and we're starting to see less of the streamlined process that unlawful detainers are were really meant for under the law. Which is why, and we'll talk about this in a little bit, some landlords are instead opting to file ejectment actions rather than unlawful detainers, even though they otherwise would not had that expedited process been in place.
And one of the things that's interesting, and this is the evolving side just from the court perspective, is we have a lot of King County, and this is King County specific, but it applies to a lot of the other counties as well. You have commissioners that are handling the initial hearings on unlawful detainer calendars. And so that first hearing that they get set is normally almost, I'm going to call it an introduction hearing, because the parties are coming before the court. It is part of the process. But in that initial hearing, it's most of the time it's a roll call, kind of the roll call, the court's going through it. And then one of the first questions that comes up is if the tenant had an opportunity to speak with any assigned counsel yet or not. And that's the basis basically for the continuance, is if most of the time if they have not had that opportunity, or if an attorney hasn't appeared, it's ensuring that they understand their right, specifically in King County and Seattle, the right to counsel in those situations, and giving them the opportunity to speak to counsel of the same. And so it's a procedural part of the process, but technically speaking, what we see on the ground is that first hearing is almost, majority of the time, is reset to a second hearing if it can't be mutually resolved prior to then you're getting actually assigned now to a King County judge in a lot of the circumstances, instead of having what normally would have been in front of a commissioner back in the day. So going through that, it's just the one thing that I can say from just seeing where all this is going and understanding is you can't have a mentality that anything is going to be quickly resolved on this side. And that's why Phil and I always advise, right when we see the problem, right when we're analyzing everything, is, how much communication is going on with the tenant? Is there an ability to resolve this in some other creative way other than, filing an action, going through that process and exhausting that side of it? Now we all know that there's circumstances where, some sort of resolution is not going to be reached, and that's what that process still remains there for from the court side. But I'm always advising everyone, if there's a payment issue, the reality of going through the process thinking that there's going to be something at the end of that process that's going to make things whole is very slim. So you really have to focus on and realize that the whole process needs to be an amicable or at least cooperative resolution to regain possession of the property. Anything to add there, Phil?
Yeah, one topic that comes up a lot is cash for key agreements. So this is one solution landlords will sometimes come up with when trying to negotiate an out-of-court resolution of a tenant. Now, I will say that these days a court is probably not going to enforce a mutual termination agreement if it comes down to it. That isn't to say that it still can't be negotiated, and some tenants, for some tenants, the promise of money if they move out is enough to actually get them to move out. So they can still work in practice, but the thing you need to understand if you do try to enter into these with one of your tenants is that you can't rely on the court to enforce the terms in light of Princeton.
All right, and then you're speaking more generally on the timeframes there, but we do want to get into something that's a little bit more on the frustration side. I think for both tenants and landlords, when that relationship just kind of breaks down, right? And what we're really seeing and trying to resolve and seeing a lot of frustration with this process, but when we have breaches of the lease or breaches or issues between landlord and tenant that are not monetary in nature, whether it's a issue with the condition of the property, how it's being maintained, whether it's an issue with pets, with additional guests, with how the property is being used for a business. And sometimes, unfortunately, there are instances of violence, both domestic violence, and assault issues that come into play, and those can happen between neighboring properties in a shared kind of apartment style living situation. And a lot of these will come up, and there are avenues to work through the court system to resolve that and try to regain possession or try to resolve the situation. But those are highly technical, and it's almost, in my opinion, and looking at these and seeing how these play out in the court side of things, it's almost a last resort to have to go that route. Now, there are situations where you obviously want to protect your other tenants. You obviously want to ensure that there's health and safety at the building, and so there's times when, let's take a specific example. The police get called to respond to maybe an assault, some act of violence at the unit, and an individual gets arrested or a police report gets filed. There's opportunities to issue a notice of termination based on that act. And when that happens, you've still got to follow the same procedural side of that. And when we're looking at that, that's a 3-day notice of termination. And the reason why we're seeing these as very technical and hard to get through, because ultimately these comes down to questions of fact. And it can be situations where it's he said, she said, there is a police report, maybe there's a situation where an individual got arrested, then released, and there nothing further came of it, or there was a report or a situation that retracted what was going on. And so these get highly technical when you're coming to the court. And you've got to remember, when you're going into that situation in front of a judge, you are asking for somebody to be removed from the property. And so that's why these are highly scrutinized and looked at. So if somebody's coming into that situation and looking at that, these are not easy things to resolve. These wind up on a tract where you're hunting down witness statements, where you're hunting down, declarations, police statements. You're looking at everything you can do to support that position, to have the offending individual removed. But that's still, most of these processes, we're seeing that go, majority of the time, have to go down the full unlawful detainer trial route, which is still an expedited process in the grand scheme of how litigation works out. But it's a very expensive process, and it's highly fact-based. And so it's one of those situations where you don't know what you're going to get in the end. It's up to, a judge's or a trier of fact is going to make that determination. And so you have to have everything buttoned up. And that's where it becomes an expensive process to look at. The other ones that are looked at, and quite frankly, we don't see much from these days, is the 10-day notice to comply or vacate. And Phil, if you want to elaborate on what that looks like and kind of some of the situations that you see those filed in.
Yeah, so 10-day notices come up when there are lease violations that are non-monetary violations. For example, if the tenant's lease says they cannot smoke in the premises and they proceed to do so anyway, that could warrant a 10-day notice. Sometimes instance of damage to the premises could warrant a 10-day notice. Basically, they break the rules of the lease that aren't related to payment of rent, utilities, etc. Like with 3-day notices, 10-day notices are very fact dependent, and they do require a lot of evidence on the landlord side. Usually you have 10-day notices if the tenant does contest a 10-day eviction based on the 10-day notice, the matter will proceed to trial, because ultimately these evictions involve a lot of dispute of fact. Usually when we see these matters get contested, the tenant will deny some or all of the facts and state that they shouldn't be evicted. So one key takeaway from both the 3-day and the 10-day notice side is, although the shorter timelines do seem attractive on the surface, you have to consider the process as a whole. And the reality of the situation is, in a lot of instances, they can be more difficult to prevail in than a non-payment of rent case or another type of eviction, because of all the factual complexities involved in these cases and the higher standard that landlords tend to be held to in these actions, which are already pretty high in other unlawful detainer actions.
And this is just exactly what Phil was getting at, that there is a very high standard here, that this statute is strictly construed against the landlords. And so when you look at that, and then you combine that with the constant evolution of the laws around this, regarding specific notices, regarding the language that must be contained in any given notice. And early on, I haven't seen it because it's been a little better on the city, the counties working with the forms that they want to see and providing the language that they want to see. But early on, we were seeing arguments based around the font size, or whether something was italicized or bolded, and that was considered a technical defect of the notice and would require a notice to be reserved. Now, when you look at that from the standpoint of a initiating an unlawful detainer or an action on these, the notice is a precondition to that. So if the notice is defective, the entire conflict that's been filed, that the litigation usually has to restart, and it's got to be based on another notice that's put out there. And so when you're looking at this, and just from the standpoint of what's the best advice on these things, is there are a lot of resources out there now Counties are producing their forms of what they want to see on certain notices. The RAWA, if you guys don't know about it, we're not, this isn't a sponsor. We're not saying anything there, but it is a great resource for landlords out there and property owners to have a basis for updates, for forms and everything. So if it is something to consider, especially if you are managing a property on your own, it's a great resource out there. Just coming back to what we were talking about with the settlement agreements and this case of Princeton, this is something that's it's been I've seen it actually frustration on both sides, where tenants actually want to enter into something to resolve it, landlords want to enter into something to resolve it, and all of a sudden we as the attorneys have to come in and say, well, that may not be enforceable, so we can't go down that route, even though these people want to resolve this in such a manner. And when that's going on, it's really forcing the landlord to file an unlawful detainer, which they normally wouldn't have had done in that process, which in my opinion, it hurts the tenant when there was that option to resolve it that everybody was in agreement on. But now they're being forced to file the action almost as a friendly litigation in order to get in front of a judge to have a stipulated order that would have been the same terms of the settlement agreement agreed to. And so that's one of the frustrations that we're seeing on that side. We're hoping that there's going to be some changes there, because I do think it's a benefit to everybody involved in those relationships to have the ability to freely contract and look at the reality of what's going on and come to a resolution outside of the court. Now, the other side of this is something that Phil had mentioned on these early on, which was the alternatives to the unlawful detainer. And what we're seeing in the court system now is there's there's a way to go through the process. It's outside the unlawful detainer. It's called an ejectment. And this is a traditional filing. I'm going to put it that way, traditional, but it's a normal case schedule. It's a normal trial schedule. It's not given this expedited proceeding. But the basis of the ejectment is a choice of the landlord to choose to go an ejectment route, asking for the individual or somebody to be removed from their house through the process of ejectment, rather than going the unlawful detainer route. And so, Phil, if you want to go into a little bit of the details there.
Yeah, so we've seen an increase in ejectment filings, especially in King County, where we're not getting as quick of resolutions on the unlawful detainer side of things as we once were. One attractive part of ejectment actions is that you can list multiple causes of action in ejectment. So, for example, if your tenant is not paying rent, you're not limited to just asking for a rate of restitution for ejectment. You could also ask for monetary damages for the unpaid rent and other amounts. Sometimes other causes of action, such as trespass, may come into play, although that's a little bit more difficult to prevail on. One downside of an ejectment action is that a tenant does have an opportunity to bring counterclaims, whereas they would not in an unlawful detainer action. However, one reason that ejectment actions, aside from the slower timeline we're seeing on EUDs, has become more attractive is that if you are to not prevail in getting a writ, you're not entirely out of luck in an ejectment action. If, for example, you have another claim for breach of contract, you might be able to prevail on that, maybe get a monetary judgment against the tenant. Some attorneys have said that they've seen less scrutiny on the hyper-technical side of ejectment actions, though I would say that it's always it's advised to be very prudent with preparing the notice. I tell my clients all the time that a notice is not simply a piece of paper that they fill in all the blanks on. I always like to review my clients' notices before they go out. I understand that my services aren't free, but I think it is worth the money in the long run when you consider how technical these actions really can be. Now, one thing that does remain to be seen on the ejectment side is since there's been an increase in ejectment actions filed in King County, some judges are getting frustrated by having to deal with all the ejectment actions, although the law does allow for a landlord to proceed with an unlawful detainer action or an ejectment action. Some judges are still of the belief that these should be filed as unlawful detainer actions and not ejectment actions. So the writing on the wall there is that I think in the semi-near future, there are going to be some adjustments made here, so stay tuned for that. But for now, we have been filing both unlawful detainer and ejectment actions.
And where ejectment actions, where you can see there's obviously the negatives is the risk of how long those can go if something can't be resolved on an early motion. So you're set out on that year-long kind of trial schedule, at least in King County. And so the resolution of that, if it can't be quickly resolved, is you're stuck in a court case that's not going to be resolved anytime soon. But as Phil was mentioning, you can have additional causes of action within the ejectment that you cannot put in an unlawful detainer. There's other aspects of it that some landlords see the benefit of, which is if there's issues with service or anything of that nature, there's still an ability to recover and go through. Whereas in the unlawful detainer statute, if you're using alternative service, I mean if you're going through and doing a posting and mailing, for an example, and there you wind up with a default or anything in the court system, technically speaking, you can't go after the monetary judgment there. So you're left with what your desire is possession of the property. But there's it's not unheard of to see certain cases that have gone on for so long, people are unable to resolve it, and there are substantial outstanding amounts. And where property owners do get demonized and scrutinized a little bit is from the sense of that they have the property, so they're fine and they don't need that payment. There's a lot of those situations where I've seen that passive source of income is somebody's lifeline in retirement. That's used to pay other things, necessities of life. So when that stream gets dried up and then they're paying additional money on the legal side to try to get somebody out, that can be a very, very life-changing issue. And so we're hoping that we're going to be able to find some more middle ground. I think the teeter-totter is going back and forth, and things are trying to sort through everything after COVID. But what we're seeing is there is an uptick of ejectment actions and people going through and weighing the risk of what can come with that versus the unlawful detainer and making a decision there. Phil, if you want to run through kind of the renewals in Seattle here.
Yeah, sure. So in Seattle, there's a general requirement that you must offer a tenant on a set lease term, a lease renewal, that must be provided 60 to 90 days prior to the expiration of the current lease term. There are certain exceptions to that. One is if the tenant indicates 60 days prior intent to move out, or if a just cause exception for renewal applies. For those of you who aren't aware, there are statewide just cause exceptions, and there's also several cities such as Seattle do have just cause exceptions on their own. So if a lease automatically reverts to a month-to-month agreement, there's no notice required under Seattle law. So in that case, you would not have to provide the lease renewal. If a tenant does stay beyond the expiration of lease and you accept payment of next month's rent, the tenant is assumed to be month to month. If there's a tenant who leaves prior to the expiration of a lease, they are responsible for paying rent until a landlord is able to find another tenant, and from there, the landlord would have to subtract any rent they received from the next tenant. Now, one thing the landlord should be aware of is that if a tenant abandons the premises early, they vacate early, and the landlord fails to make a reasonable effort to re-rent the unit, the original tenant might have a defense that that landlord failed to mitigate their damages. So the bottom line is if you are a landlord in Seattle and you have a term tenant, be prepared to offer the tenant a lease renewal. Do look into the exceptions, but the general rule is that it must be offered.
Right, and that's just a big thing to be aware of, and it's more of an awareness and calendaring, so that it doesn't sneak up at the end of a lease, and you're going, oh, I was trying to either do something differently here, or I wanted to still work with this tenant, or whatever it may be. It's just something you put there, and it's part of it now. We just have to lean into it. That's not going away, and that's not going anywhere. And so it's just being aware, calendaring out those items, just making sure that you're sending the appropriate notice on those issues. And now, as we get into this, I think a lot of people are curious. There's two big House bills that came out as we originally were discussing, and this is just showing how much is changing, how fast the things are changing within the state of Washington, and locally within King County. But the House bills in particular. The House bills, if you want to look it up, is HB 1003. And that is a big one because it revises a lot of the notice and service requirements on eviction notices that have been in the same, under RCW 5912-040. Those service sides of things have been fairly static for a long time. And so this House bill revises those and creates some items that everybody needs to be aware of in regards to serving notices and initiating a lawsuit. And the other one is HB 1217. And this is the big one that everybody's seen on the news. Everybody has their different opinions on how this goes, but this is more or less a cap on what can be rent increases on things. And now there's some interesting dynamics of this, which if people have looked into it and looked kind of the history of it and where this is going, they've implemented kind of a limitation on how much can be increased in any 12-month sides of things with regards to a lease. But also there's some big exemptions that are interesting to note. One of them being the exemption for anything that's gotten a certificate of occupancy within the last 12 years. So it's one of these things when you're looking at that, historically I was fascinated, and I was like, oh, that's interesting because there's so much new construction here in Seattle, and where did this exemption come from, and how does that really play out? And the big part of that was when they were looking through this on the House side, they didn't want to prevent or distract from people coming to Seattle to continue with building and development. And so they took that into account and putting through these exemptions. But it also is interesting to note, because then you're thinking, okay, well, now you're, the ma and pa landlords that have really taken the brunt of a lot of the COVID, a lot of the changes in the law and the cost. And a lot of these times they'll be, and it's awesome to see. You'll see people that have had the same tenant for 10, 12 years. But you'll also see times where you're looking at that, and that same tenant, is well below the market rate, and an owner is looking at something and saying, okay, well, I'm going to make some improvements and increase here, and there's some big limitations on what can be done there. So we're going to run through those with our last bit of time here. I'm going to quickly go through House Bill 1003 because it's more just to be aware of and to look at it, and I want to get into a little more detailed discussion on HB 1217. But it's just, this became effective July 27, 2025. So you just got to be aware that there's certified mailing is now required. And then your notices that go out, we used to be able to have this ability to say within 30 days of receipt of this notice, within 5 days of receipt of the notice, or whatever it was on those fronts, we could track that if it was served or if it was mailed and you had a confirmation of mailing. You have to have a specific date now that compliance has to come into in terms of, lease termination, compliance on a non-payment, compliance on a 10-day. You have to have a specific date in there. So people got to be aware of that, change the way they practice that point. And there is one thing that did come up through it, which is a very small, I'll call it a win for landlords, but it's really just, you no longer have to mail from the county in which the property is located. So before, if you looked at it, there's this really strange language in there that the mailing had to be sent. If the property was located in King County, it was only effective if it was sent from King County. There's a lot of people that have properties in King County that live in Pierce, live in Snohomish, so it did create some technical issues, so they got rid of that. But now I want to run into just kind of quickly notices that were served. We get a lot of questions where what do I do with notices that were served before this July 27th, 2025 timeframe? How do I do it if they haven't expired before July 27th? We are incredibly cautious on that because the notice is the start of this whole thing. And so we are advising if you have a situation like that, it's normally going to be the best approach to start over, to issue a new notice, restart that process, because it's just not worth having the prerequisite to, if it has to go the unlawful detainer route, being defective. So if you have a situation where something went out prior to July 27, 2025, you need to look at it and you need to understand that it might be the best practice just to reissue that. All right, now we're going to run into HB 1217. So Phil, if you want to run through some details there.
Yeah, so HB 1217, this is the renting increase bill that we were talking about. The effective date was May 7th, 2025. On a similar note, as with the other House bill, question that comes up a lot is what happens with notices that were served before May 7th but do not expire till after. We'll get to that in a little bit, but the bottom line is that, like with the notices Rob was talking about, with eviction notices, we generally recommend reserving those if they were not compliant with the new House bill. Again, it really is a matter of erring on the side of caution here. A little bit more about HB 1217. There are no rent increases permitted during the first 12 months of tenancy. There's a new rent increase cap of 7% plus CPI or 10%, whichever is less. So now, on a statewide basis, 90 days is required. 90 days notice is required to increase rent. So many of you may be asking, well, what about cities such as Seattle, where there is already a 180-day rent increase requirement? For cities that do have a higher rent increase requirement, the answer is that you still have to follow a city law, and you have to go with the longer period. So no, unfortunately, Seattle landlords are not exempt from the 180-day requirement after the passing of this new bill. So statutory form is now required for rent increase notices. It used to be the case that there was no such statutory form. So that has been a big change from this bill. Some organizations such as RAWA have an updated form that you could use. Again, this is not an advertisement for RAWA, but we really do think they're a great resource for staying up to date on a lot of these issues, for access to their form database. So it's something I would definitely look into if I were a landlord. There's also a requirement on rental parity in lease types. So a lot of times when a new lease term is being offered, a landlord might offer a discount for a fixed term versus a month-to-month tenancy. So the discounted rate for fixed term tenancies cannot exceed 5%. So something to be aware of if you have tenants whose leases you need to renew. Also, the Washington State Department of Commerce does have data with respect to the CPI amount. So you can access that when trying to determine how much you want to increase rent.
And that's a big resource. So part of this is we are seeing, with all the hyper technicality that comes with everything in this industry now, we are seeing states, local cities, and everything doing more to at least show what they're looking for to land. So there's a lot of resources out there. One of them is at the Department of Commerce in Washington. If you go, this is part of HB 1217, is they actually had to produce this. They have a form-based notice that they have on their site. They have the CPI index so that you can see what's going on with that. And there's a lot of resources out there to help get through the process, because it is so hyper technical that you're looking at it and you're thinking, where do I start? Where do I go? And these are the places that you should be looking at and going through. So we want to utilize those, and we want to help landlords understand, because ultimately we want to be a value add to any of our clients in any situation. It's not, no one wants to go into litigation. No one wants to go to court. That's not a fun use of time. That's not it's a stressful event. No one wants to be in that combative relationship, especially in a court setting. And so when we're looking at these things and just making sure, if we have to go through that process, if you are forced to go down that road with a tenant, or with a situation that just cannot be resolved through amicable sides of it, you want to have the most information you can to get in front of it, to see what do I need to do. And so those resources are invaluable. There's a lot that can come through, and it's been great to see the rise of AI and the ability to synthesize and give an overview of certain things. The difficulty with that in our current area and practice of law is there's so many nuances that are not uncovered in that process. So I've had a lot of people come in and say, oh yeah, no, I found this form online. I was able to go, I looked up the process through Chat GPT, and they said, follow these steps, and this is what I do. And you're looking at it and you're going, hey, that's great, because it gives you this baseline to at least be able to jump to know what the process is to start. But the notice you served actually did not contain this specific language that's necessary for this county. And that's something that hopefully in the future, everything is going to be more streamlined, and there's going to be more and more resources so that people don't make those mistakes when they're doing it, have to restart. But that's also why it's imperative to at least have that contact with an attorney or with somebody that's knowledgeable in the area to say, hey, okay, here's what's going out. Is this okay? And just looking at that from the overview of it. So everybody that possibly had questions on the CPI. So for this year, it's up on the website for the Department of Commerce, but it's going to be published, and it's going to come out starting June 1st, 2025. So each year they're going to do it. So that the cap this year is actually at the maximum. It's at 10% if you go to the website, the Commerce website. But it's going to be revised every year, and then you'll know what percentage you can do. I think, if my memory serves correct, the next year I think it's at 9.6%, possibly right around that. So just take a look at that. You should know, be accustomed to what's going on there, and then we brought it up with HB 1003, but with HB 1217, what happens with these increases that were sent out prior to this coming into effect? Now, remember, this is May 7th, 2025. And this is where I want everybody to understand, because if you've paid attention to this and you've looked at the news, the AG's office has actually come in pretty hard and on notices that were defective after this came out. So when you look at that, and you look at a number of different landlords that were found to have violations of this from the AG's side of things, it was interesting to see from my perspective, because this had changed so quickly, and this was something that came about, and a lot of people, quite frankly, were caught off guard when this came in, and unfortunately there was actions that weren't taken that should have been taken, or differences on the notices that should have gone out. But it didn't change the fact I quite frankly thought that there would be a little bit of a grace period with the AG's office while everybody got up to speed, everybody learned and was trying to adjust to this. But there wasn't the same kind of grace period. So you can expect to see from the AG's side of things, I would expect to see just kind of a more heavy-handed approach on this. And this is why it's critical to understand where these limitations are within this House bill and what those increases do. So I just wanted to put that out kind of as a disclaimer for everything that's going on, that you want to work with the tenant, you want to work with everything that's within the means of the law if there is going to be a rent increase, but you just got to be aware of all these technicalities that come into place now. Phil, did you have anything to add on the HB 1217?
Overall, I would just add that this is exactly why Rob and I recommend taking a very conservative approach to interpreting these new laws. We don't do this to make things difficult for you guys. We do this because the reality is not complying with these actions can result in the tenant or the AG filing a complaint for failure to abide by the requirements of the new House bill. And as Rob was saying, that we're already starting to see these actions taking place. The AG's office does not appear to be very lenient on landlords coming up to speed with the new requirements. So for that reason, sometimes the best approach is to serve a new notice when in doubt. Sometimes it's just not worth what you might get out of enforcing the new rent increase when you're dealing with a situation that you might be facing penalties as dictated by the new law.
Where some of those are, it's it's a $7,500 fine for each violation, in addition to other remedies, which include penalties to the tenant. There's situations on that. So, and attorney fees and costs. So you need to be aware. You need to be up to speed on where that goes. Some of the exceptions to the new rent increase requirements. You'll see there the newly constructed residential buildings. That's part of it. Owner-occupied units, low-income housing, tax credit properties. Those are exempt from it, and nonprofit owned affordable housing. And so if you're falling into one of these exemptions, that's great. You just got to be aware of where all this lines up, and that is the best approach you can still have. Everybody is going to be on the same page. Everyone's going to work on that. So if I'm going to leave you with anything today, and I thank you all for being here, but it's not that hard to be a good person. It's my favorite quote. And thank you all for taking the time to be with us. And again, if you have questions, please put it in the chat. I'm sorry we had a lot to cover today, so I didn't get to the specifics. But if you put it in the chat along with your email, I will be able to get back to you. Phil and I will look through that, and we'll be able to touch base with you if you have a phone number or an email. Happy to talk. If you my contact information, just so everybody has it. We'll leave you with that, but if you, please feel free to email me, give me a call if you need it. I love talking to different clients, different people around the area. Thank you so much for being with us today, and we all really appreciate it.
Thank you, everyone. I wanted to end on also one last note as well. Another aspect that's frustrating with all these new changes is that a lot of them aren't very favorable to property owners and landlords. So another thing you can do to potentially improve the situation is you can write your representatives, you could show up at town halls, you can join organizations such as RAWA that do fight for the rights of property owners. So we do encourage you to make your voice heard. We said this at previous webinars for those who have attended last year or the year before. But there are resources out there for landlords. There are opportunities to make your concerns heard. So we do encourage you to use your voice.
Thank you all.